Hello, my name is Sally Nichols and I'm the Managing Partner and founder of Nichols Family Lawyers. We're a law firm that's based in Melbourne and Geelong, and we only do family law this year. And the significant impacts these changes will have on family violence and the role family violence plays in dividing property. These reforms build upon the landmark changes introduced by the government earlier this year, which came into effect in May 2024. Those earlier changes focused on improving safety and simplifying the framework for determining the best interests of children in parenting disputes. The reforms I am focusing on today focus on legislation that now requires courts to consider the impact of family violence, specifically in property settlement decisions. We'll also touch on the introduction of clearer rules for property settlement, looking at the protection of confidences and the court's new approach to the treatment of pets in these cases. So let's dive into these important changes and their implications. Before we get into the specifics of the reforms, let's first understand what family violence is in a family law context. Family violence refers to any violent, threatening, or coercive behaviour that controls a family member or causes them to feel fearful. This includes things like assault, stalking, psychological abuse, and financial control. The statistics show that about 80% of cases filed in family courts involve some form of family violence, and nationally, 1 in 4 women experience it. This is why these reforms are so crucial. The new amendments now explicitly define financial abuse as a form of family violence. Things like controlling money, sabotaging employment, or forcing a person into debt without their knowledge. Under these reforms, the courts are now required to consider how family violence impacts the division of property, especially how it affects a person's ability to contribute to the asset pool. This is a significant change, ensuring that victim survivors aren't overlooked in the property settlement process. So let's talk about the specific amendments to property settlements. The Family Law Act introduces new provisions that address the economic impact of family violence. The new laws bring 3 significant reforms that directly impact on property division. Firstly, it includes economic or financial abuse as a part of family violence. This is a huge step forward, recognising how financial control and coercion can be tools of abuse. Secondly, it explicitly states that family violence can impact a person's ability to make both financial and non-financial contribution in a relationship. Lastly, the new law recognises that family violence can have long-lasting effects on a person's financial stability and well-being, which must be considered in property settlements. So these reforms provide a more nuanced approach to property disputes, ensuring that victim survivors' unique circumstances are fully acknowledged. Prior to these reforms, victims of family violence could rely upon a claim known as herein claims to argue for an adjustment to the property pool. Founder of Nichols Family Lawyers. We're a boutique family law firm. So why is it better for the law to explicitly require courts to consider the impact of family violence? Before these changes, victim survivors could only rely upon the common law, specifically the herein case from 1997, which required them to show that family violence significantly affected their contributions to the relationship. The problem was that this was a high bar to meet, and the courts often didn't have the clarity or legal basis to make meaningful adjustments. With these reforms, family violence, including economic and family abuse, must now be considered directly in the law. This makes it easier for victim survivors to have their experiences reflected in property settlements. It's a real game changer, and I believe it will make a huge difference for victim survivors seeking justice. Now let's talk about the process of proving family violence. If financial abuse has occurred, like controlling access to funds, accumulating a debt in a person's name, or preventing someone from working, that must be shown in evidence in court. It's important to gather the right evidence. This could include things like bank statements, communications such as texts or emails, demonstrating control, or testimonies from witnesses who observed the abuse. Victim survivors may also need to document showing a lack of access to financial resources. Having solid evidence helps the court understand how family violence affected both the victim survivor's financial situation and their ability to contribute to the marriage or relationship. Of sensitive information shared with professionals. Under the new amendments, the court can prevent the disclosure of private information shared with professionals like doctors or therapists if the court considers the disclosure as amounting to confidential disclosures. This possibility is aimed to prevent victim survivors from being re-traumatised by having to relive their experiences in court. It is also hoped that professionals can be more reassuring and encouraging of victim survivors to be more open about the abuse they've suffered, as if their sensitive information fits into the necessary category, that information may be protected. Therapists and doctors need to become educated about the new parameters to assist in this process. Lastly, there's a significant shift in how the law treats pets in property settlements. Pets now are recognised as companion animals, or after June 2025, rather than property. So while pets are still legally considered property, they are now given a unique status as companion animals.
Yeah.
This is especially important in cases of family violence, where pets are sometimes abused or used as tools to control victim survivors. The court can now make specific orders about the ownership of companion animals, considering factors like who's cared for the pet, any history of abuse, and the emotional attachment of children or parties involved. This more thoughtful approach acknowledges the role that pets play in families and ensures that their well-being is considered in property settlements. So in conclusion, these reforms are a huge step forward in ensuring a fairer and more just legal system, particularly for victim survivors of family violence. The amendment to family violence law, property settlements, and the treatment of sensitive information and pets represents a more equitable approach that reflects also the lived experience of those affected by family violence. Thank you for joining me today as I explored these critical changes. I hope this has provided some valuable insights into the reforms ahead. If you do wish to obtain any legal advice on this topic or general family law advice, please visit our website, which is linked in the description.